Good afternoon. Thank you so much for joining us today for yet another extremely topical and extremely timely EMET webinar. We are profoundly honored today to have a friend of longstanding, Ken Marcus, who has a very wonderful, long, illustrious history of advocating for the rights of all minorities, including Jews, and our nation's educational institutions. Most recently, he served as Secretary for Civil Rights in the Department of Education, a position that requires Senate confirmation. He has recently returned to a position at the Louis D. Brandeis Center for Human Rights Under Law, an institution that he founded, and he's presently serving as chairman of their board of directors. The Louis D. Brandeis Center for Human Rights Under Law is a wonderful institution, I have to say, and their mission is to advance the civil and human rights of the Jewish people and to promote justice for all. It is extremely important right now that we hear about the rights of all students, how they've been affected, particularly by the coronavirus, and particularly on the rights of Jewish students who we know have had many, many challenges, especially in universities throughout this country. So without further ado, it's my profound and distinct honor and privilege to welcome our audience to listen to Ken Marcus. In general, Ken, what do you feel were some of your greatest accomplishments and some of your frustrations while you were serving as the Secretary for Civil Rights in the Department of Education?
Thank you, Sarah, and thank you for that extraordinary introduction. It has always been my honor and privilege to work with you and with EMET on a variety of topics. You were hugely supportive during my confirmation process, and I deeply appreciate that. But beyond that, over a period of years, your leadership in various topics, including in particular, our opportunity to work together to reform Title VI of the Higher Education Act. Really, you've done very impactful work there, and it really has been a privilege working with you. So thank you for your question about what I think I accomplished at OCR. I know that I was supposed to come up with 3. There are reporters who would have given my answer if I could have come up with 3 or fewer. And yet, there really are a number of things that I was pleased with during that time. Of course, to the extent that I contributed to the president's executive order on anti-Semitism, I would say that was a significant source of pride. It's something that I've been working on for many years before, and I think it is a huge milestone in our efforts as a country to deal with anti-Semitism, especially on college campuses. I think that the major Title IX sexual assault investigations that I oversaw at several research universities were also something that I was very pleased with, although the facts in some of them were horrendous, but cases like Michigan State, Penn State, and University of Southern California, and perhaps in particular, our investigation of the failure of the Chicago public schools to address large-scale incidents of sexual assault of high school students. And I think putting a national spotlight on the problem of sexual violence, not just in college, but in the public schools, and creating a national initiative on that topic, I think was important for OCR. I think that creating an initiative to deal with the really awful problem of misuse of restraints and seclusion of students with disabilities in the public schools, and partnering with the Office of Special Education and Rehabilitative Services to provide tools to educators to avoid doing such things. We created the so-called Open Center, the Department of Education's Center for Outreach, Prevention, Education, and Non-Discrimination, which I think was an important way of dealing proactively with civil rights compliance rather than just reacting after the fact when students' rights were violated. We developed new regulations to deal with sexual harassment and sexual assault under Title IX. We created a new case processing manual, which instituted a system of appeals as well as a quality review process for OCR investigations. I'd say those were a few of the ones that I was very pleased with. We also very substantially increased the number of cases that we were able on an annual basis to close in a way that required schools to create change. So while the prior administration had talked quite eloquently about wanting to address civil rights and opened a lot of cases, they weren't able to close as many, and in particular, they weren't able to enter into agreements in which schools were making changes for students. So I think that we were able, in some cases, to double, or in some instances, increase by sixfold or more the number of cases that we were closing with change. As you can tell from that, those were not things that I was able to accomplish on my own. I would say they were team accomplishments of the entire Office for Civil Rights, but I was honored to serve as the head of that agency when we accomplished those things.
Excellent. How in particular has the coronavirus affected discrimination, anti-Semitism, racism on campuses throughout the country?
Well, that is a big question that I'm glad you're asking. And if I can interpret campuses and discrimination broadly to include a host of different groups and both K-12 and higher ed, I would say that it is a very tough time for students and families across the United States. Particularly impacted, of course, are the families in which there have been infections and losses. And there are students going to school at the beginning of the school year having lost close relatives. So the illness itself has been devastating for many. The resulting economic closures and loss of jobs impacting many families. So there are huge hardships affecting many children and students as the school year begins. The school closures exacerbate some of these problems, especially for certain groups of vulnerable students. I would say that I'm particularly concerned now about students with disabilities in areas with school closures. There are some disabilities, of course, that can be addressed even with closed schools, but others that cannot. Some students with individual education plans requiring speech, physical, and occupational therapy that they will not be able to receive. Students with autism whose conditions may be exacerbated. All of those issues. Then there are schools that are not doing what they need to implement the new Title IX regulations absent face-to-face training, and some schools that have not been moving forward on investigations that they're required to do as a result of the coronavirus. But then there are specific issues facing different ethnic and racial minorities, English language learners in particular. In September, I warned educators across the country that in light of the coronavirus, there was a risk that Asian American students would face particular harassment. And sadly, that has been true. But it's also been true that anti-Semitism has spiked worldwide in the wake of the coronavirus, as Jewish people have been scapegoated for it in many parts of the world. And some of this has fed in the United States to what had already been increases in anti-Semitic incidents in elementary and secondary schools. Meanwhile, on college campuses, there has been a continuing increase in anti-Semitic activity, which I think has been worsened in recent weeks and months as well.
Right. So this brings us to how we first met. And as I recall, prior to 2008, for years I had been working for revisions to Title VI of the Higher Education Act. And I remember first meeting you when you came to a seminar I was speaking at Capitol Hill about Title VI of the Higher Education Act, and you had thought it was Title VI of the Civil Rights Act as you were acting Assistant Secretary for Civil Rights under President George W. Bush. That was quite fortuitous, and I'm very grateful for that. And then we began working, I think, and collaborating in some informal ways about Title VI of the Higher Education Act, and which is very different from Title VI of the Civil Rights Act, but they're like intersecting Venn diagrams, I think, in terms of many of the universities. In fact, we're doing a study right now, and it seems like most universities that have Title VI of the Higher Education Act Middle Eastern Studies programs have professors that make highly discriminatory comments about Israel and the Jewish people. A year ago, March 22nd through 24th, there was a particularly pernicious conference sponsored by the University of North Carolina together with Duke, where there was a rapper, Tom DeFar, who said some really egregious, disgusting anti-Semitic comments. And that provoked Representative George Holding from North Carolina to write a letter to Secretary Betsy DeVos. And Robert King had opened up an investigation and sent a letter on August 29th, I think, of 2019 to the University of North Carolina. Would you like to discuss a little bit the contents of this letter and how this played out?
Sure, I'd be happy to. There were, in fact, two letters, both important. There was the letter from Congressman Holding to the Secretary dealing with this conference and pointing out that there could be a violation of the Higher Education Act, which, thanks to our efforts, but especially your efforts, Sarah, and your leadership, requires that applicants for these area studies funds to certify that they will provide a balance of perspectives and a diversity of views. And there was a question as to whether UNC and Duke, in fact, were providing a more monolithically anti-Israel perspective. So the question for Assistant Secretary Bob King of the Office of Post-Secondary Education was whether there was a violation of the Higher Education Act. At the same time, the Zionist Organization of America wrote to the department alleging that the same conference, as well as surrounding circumstances, swastikas in libraries and other incidents, amounted to a violation of Title VI of the Civil Rights Act because they created a hostile environment for Jewish students. In response to that second letter, the ZOA letter, we investigated, or we began to investigate the conferences. But early on in the process, both universities, UNC and Duke, indicated an amenability to try to work out the problem and entered into an agreement which we prepared for them, in which they agreed to change policies, procedures, statements, training, meetings, and other things to include very explicitly a discussion of anti-Semitism, and it indicated that the prospect that they would potentially adopt an appropriate definition of anti-Semitism as well.
Okay, speaking of appropriate definitions of anti-Semitism, President Trump on December of 2019 passed an executive order, signed an executive order, I should say, using the International Holocaust Remembrance Alliance definition of anti-Semitism. I have a number of questions about that, but one is a denial of the Jewish people of a right of self-determination. And as we're exploring what's going on in many of these Middle Eastern studies programs, there is a strong denial. Many of these professors have, compared Israel to a Nazi state or to South African apartheid. And in fact, in the IRA, International Holocaust Remembrance Alliance definition, that example is, for example, comparing Israel to a Nazi state. My first question is, how does one go about enforcing this? Because it is a very, very difficult thing, because the universities are hiding behind a shield of academic freedom and free speech. And how does one go about enforcing this? And nobody wants spooks in the classroom. Nobody wants. So how does one go about investigating whether or not they are in compliance with this executive order?
Sure. I'm glad you're raising the president's executive order on anti-Semitism, because I think it really is a huge step forward, and is, as you know, it's something that I had urged for years. Yes. Although the idea of putting it in an executive order as opposed to legislation was a new development with this administration. I think it's hugely important in shifting the culture in higher education, so that there is an understanding that anti-Semitism, in any of its manifestations, including its anti-Zionist manifestations, should be treated as seriously as any other form of hate or bigotry. And I think that this new order does as much as anything to establish that principle. I actually agree that universities should use academic freedom and freedom of speech as a shield where warranted, and would not want either the executive order or anything else to invade the freedom of speech. The executive order, I think, is well crafted to avoid that. It is possible to be well used. It is possible to be misused. But I think that its language is very useful. By its own terms, it insists on conformity with the First Amendment, as in fact does the OCR resolution agreement with UNC. And it provides that the definition should be used specifically in order to determine whether conduct is motivated by anti-Semitism. It is not intended to be used to criminalize or in any other way prohibit any form of anti-Semitism. Because as you know, Sarah, just as many forms of sexism are constitutionally protected, and racism and homophobia, there's some forms of anti-Semitism that are constitutionally protected as well. But often what we see on campus is not free speech, but rather conduct that is aimed at Jewish students that is not constitutionally protected, and that should not be tolerated. And the executive order facilitates OCR as well as civil rights organizations like the Brandeis Center to deal with it.
Right. So how does one draw the line? If one, I mean, I've had calls from students in my office about a professor singling them out for discrimination because they're wearing a yarmulke or a Star of David. One student who was in a class in film that's under a Title VI school, and they were only showing films that were basically, pro-Palestinian, talking about Israel as though it was an apartheid, Nazi-like state, and he wanted the other point of view and got into considerable trouble with his professor for asking for the other point of view. ended up failing the class, actually. It was awful. And he was an A student. So how does one go about protecting students from this kind of discrimination? I mean, there it was blatant discrimination, and this student was asked to check his parochialism at the door, and that he was there for an education. So how does one fight this, and how can the Brandeis Center help students like this?
You have to look at each case on its own terms. And there are some cases that are going to be more Higher Education Act cases and others more civil rights cases. So for instance, if one is talking about viewpoint bias within a Middle East Studies program, that's the Higher Education Act. If one is talking about hostile environment for Jewish students, that's the Civil Rights Act. People often ask me, what are the First Amendment rules on anti-Semitism? And my concern here is that we not have a separate set of First Amendment rules for anti-Semitism. There can't be one First Amendment for Jews and another for Gentiles. We have to understand that First Amendment protections in the university are fairly strong and should be, and we wouldn't want them to be otherwise. But we see Jewish students who are harassed in ways that have nothing to do with free speech. And we see different treatment, so that Jewish students are treated differently than non-Jewish students. There's no free speech element there at all.
Right. Okay. So there have been a number of letters that have been written. First, it was Representative George Holding from North Carolina that wrote about the University of North Carolina, Representative Dan Riggleman from Virginia, who wrote about Georgetown, Representative Doug Lamborn from Colorado, who wrote about UC Berkeley, and Representative Scott DeGenlis, I hope I'm pronouncing his name right, who wrote about Yale. I know these are ongoing investigations, but how is this handled when a member of Congress writes to the Secretary of Education? What is the procedure?
I think that you are referring to a number of letters from members of Congress about Middle East studies programs that allegedly violate the Higher Education Act.
Right.
So when the secretary gets a letter of that sort, as a matter of normal course, they would be sent to Assistant Secretary King and the Office of Post-Secondary Education. Now, if there's an allegation that Jewish students are facing discrimination or harassment, as at UNC Duke, it would be different. But in these other cases, when it's about a problem in the Middle East Studies program being biased, it goes to the Office of Post-Secondary Education, where the question isn't whether there's been discrimination. The question isn't whether the executive order is implicated. The question is simply whether the university has acted in a way that's inconsistent with its certification about balance of perspectives and diversity of views.
Right. It does seem to be endemic. I have to say, we are now doing a comprehensive study, and as you know, I worked my gut out to pass in 2008 the amendments to Title VI of the Higher Education Act, which was supposed to ensure a diversity of perspectives and wide range of viewpoints, but it doesn't seem to be adhered to.
Well, it isn't. And of course, as we know, I mean, that was heroic, Sarah, you got it accomplished, that the requirements were put in place, but there really weren't any enforcement teeth there. And I think that's why there was really no action for years after that, really until this administration, although we started making progress late in the prior administration. The first progress was when we got the prior administration to agree at least to score applications to see how well they were indicating they would provide diversity of perspectives and balance of views, rather than just checking a box to see whether there had been a form included. That was very important, and we had other organizations, but I think that was something that I was very proud of as a project we worked on with you. Then the next step was when we got the department to start looking at the end of each grant period and to see whether it had been done. Because otherwise universities realized that the department was looking at a lot of things, but not this one. So it's important that they realize that the department is looking at it. There still aren't formal procedures. There still is no regulation implementing the Title VI reforms. So at best, it's going to be ad hoc if the assistant secretary wants to take something on, and the Office of Post-Secondary Education really doesn't have much to rely on in terms of formal rules, no regulation. There really isn't a strong process. So I would say beyond just a need for more investigations, the department really needs more rules and processes, and they need to be transparent so that institutions know that this is something that the department is going to look at carefully and is going to enforce firmly but impartially.
Right. Okay. Speaking about transparency, I know that there is a Transparency in Education Act that was passed many, many years ago that says that anytime a university receives funding from overseas, it has got to be at least registered with the Department of Education. Well, I know when there was the Jamal Khashoggi affair, all students from MIT said, don't we get money from Saudi Arabia? And they noticed that that was not registered anywhere. This, is often overlooked and ignored. Saudi, as we know, at least in Georgetown, Saudi Arabia has given $20 million, but Qatar has given $300 million. And they have a Georgetown University, Walsh School of International Affairs in Qatar. So what kind of enforcement is there on the universities to at least disclose the Department of Education? I would like more transparency where, beyond the Department of Education, people applying to these universities would know that these universities are getting money from these foreign governments and nothing is for free. There are always strings attached in terms of the objectivity, I think, of a department when you know you're getting a great deal of funding from these sorts of nations. So is there any kind of mechanism in place?
Under this administration, there was very little, if any, enforcement that happened. I'm not aware of instances. Under Secretary DeVos, there has been, I would say, fairly vigorous and high-profile efforts under Deputy Secretary Mick Zais, and I would say that Acting General Counsel Reed Rubenstein has been very energetic and active in this. And they have sent a number of letters, and they have very effectively used the weapon of public shame to embarrass those universities that have received not just millions or tens of millions, but in some cases, hundreds of millions of dollars in illegally undisclosed foreign assistance. And we don't always know what is happening with that money, and it could be innocent, but we also know that some of that money has funded research universities known for their nuclear technology, and that some of the funding countries are understood to have an interest in nuclear technology. So this is a major issue. It is an issue very much involving the Gulf states, but also involving China and other countries. I think that the current and I'm excluding myself because this was not in my jurisdiction. I'm not patting myself in the back, but my colleagues have really been the first to invigorate this area of the law. But the question I have is, why should they be limited to the weapon of public shaming? Shouldn't there be some teeth to this enforcement? Even if you could get a fine of, let's say, 5% of any illegally undisclosed contributions. I mean, there's one institution that had forgotten $250 million in these contributions. You'd certainly get their attention if you required even a portion to be returned to the Treasury of the money that they illegally failed to disclose.
Excellent, excellent. Okay, so I actually am going to sharpen my pencil, and aside from everything else I'm doing, because of this discussion, I would like to try to work on formalizing a procedure so that we can look at these Middle Eastern studies programs in particular to see whether or not they are living up to the spirit of the 2008 amendments. And I think it's very, very important that we take it from there. But before I open up the floor for questions, I have one further question, and it might be extremely naive and not that intelligent, but President Trump had this wonderful December 11th, 2019 executive order. When he leaves office, does that sunset with him? What is the status of an executive order? If we get a Biden presidency, does that just disappear?
I'm just trying to get my mind around how it is that Sarah Stern could possibly ask an unintelligent question, and I just don't think it's going to happen, Sarah, so I don't think you have to worry about that one. The executive order wouldn't simply sunset by its own terms, but of course it is vulnerable to being rescinded with a stroke of the pen. I think that Senator or Vice President Biden, if elected, would be unlikely to do that, but it's not inconceivable. He does have various political pressures from different parts of his party, so it's something we should be worried about. I think the more immediate problem were he elected is not so much that he would immediately rescind it, but rather that his administration would simply ignore it. That they would possibly leave it on the books for a while, but not enforce it. And that is what I think would be highly likely. The worst case would be rescission, but the most likely case is nearly as bad, which is that they just ignore it, when in fact it is the most important thing that any president has done to address campus anti-Semitism.
Right, thank you. And just before I turn, tell us a little bit about the Brandeis Institute, and in particular, Eliza Lewin was telling me about this wonderful program called Jigsaw. Could you tell us something about that?
Sure. So the Louis D. Brandeis Center for Human Rights under law, not to be confused with the University in Massachusetts or the law school in Kentucky, is the organization that I funded 9 years ago, founded 9 years ago, to combat anti-Semitism on colleges and more generally advance the civil and human rights of the Jewish people and promote justice for all. We have been using law and public policy to protect Jewish students from anti-Semitism on college campuses. We have had law students in chapters around the United States. We have filed administrative claims and a lawsuit and taken other actions and worked with administrators around the country, showing college presidents and deans what they need to do legally to comply with civil rights obligations to Jewish students. We make it clear that anti-Zionism isn't just a political dispute in which they have to stay neutral, but in many cases it can cross the line into a form of hate or bigotry that has to be addressed as seriously as any other form of bias. Eliza Lewin is the illustrious attorney, immediate past president of the American Association of Jewish Lawyers and Jurists, a very distinguished lawyer and an appellate litigator who succeeded me as president of the Louis D. Brandeis Center and whom I work with now. She remains the president. And she created a new and important program within the Brandeis Center. For years, we had chapters for law students, but she has supplemented that with a particular program of law student fellows around the country who are specially trained to address anti-Semitism and other forms of bias, and to work with college students, so that if college students see something, hear something, but may not feel comfortable talking to professionals at major organizations, but maybe they feel comfortable talking to another student, these law students are now equipped and able to work with them and with us, and to work to bring changes from within their colleges and universities. And it's been a great program. The Jigsaw program at the Brandeis Center, great work by Lewin.
Great, excellent. Okay, and now I'm going to hand the podium over to our wonderful Director of Communications, Sarah Leah Thompson, who will read some of the questions that have come in.
Thank you, Sarah. And thank you, Kenneth, as well, for joining us today. Really appreciate all of your insights. We have received a number of questions from the audience, but unfortunately, we won't be able to go through all of them, but we'll do our very best. So the first question we've had: what will happen to the Title VI enforcement on campus given your resignation?
Well, I'm flattered by the suggestion of my importance in the enforcement, but what I'll say is that just as I had a brilliant successor in Eliza Lewin at the Brandeis Center, I have an extraordinary deputy who is now my successor at the Office for Civil Rights. Kimberly Ritchie, whom I recruited out of law school many years ago to serve at OCR, and whom I then promoted a year or so ago into the position of Principal Deputy Assistant Secretary, is now the Acting Assistant Secretary. And while she has by no means made a career of addressing campus anti-Semitism and has expertise in a wide range of areas, I'm fully confident she is a first-rate civil rights official, and we built a strong team that remains in place.
Thank you. Specifically talking about an instance that happened at Duke and University of North Carolina, was there a follow-up to that event that happened, and was there any need to change their policies?
Yes, I'm not sure if the question was written before or after I answered Sarah Stern's questions about that, but yes, the resolution agreement for both of those institutions included a provision under which they would have to change their policies to address anti-Semitism more explicitly. It had various requirements about the new policy and what had to be done with respect to the policy, the training, et cetera, around the policy. So that was required, and the cases are now in monitoring, which is to say we're now still in the period during which OCR is monitoring both institutions to ensure that they remain in compliance with their agreements.
Thank you for following up about that. I appreciate it. For the next question, how has BDS been handled on campus?
Well, that's a difficult one. I would say not always well by any means. When the Brandeis Center first started dealing with BDS, it was not with BDS itself, which we saw initially as a debate among students. We were concerned more with the impact outside of the hallway. So, for instance, I recall one campus where there was a really offensive debate over BDS, and then afterwards, one of the participants went out and spit on a student who was wearing a Star of David necklace. So we took on the case about the student who was spit at, but didn't really address the BDS itself. That was many years ago. We then realized that while not all advocates for BDS are anti-Semitic personally, they frequently traffic in anti-Semitic stereotypes. And moreover, they were using what had become at that point the primary technique for trying to harm Jewish students, the Jewish people, and the Jewish state. And so for that reason, we've done much to advocate against it, specifically as an anti-Semitic movement. Some universities have spoken out against it, including at the presidential level. Often they criticize it as an infringement on academic freedom. I prefer if they would be more forceful and point out that it is not only that, but more importantly, that it is a hate movement and that it should be treated as such. But I'll say that BDS is a technique. It is deeply problematic, but dealing with BDS is only part of the bigger picture, which is dealing with anti-Semitism. We had anti-Semitism on campuses before BDS. I would say 15 years ago, we looked at the apartheid smear as being perhaps the preeminent way of attacking Jewish students on campus, this canard that Israel was apartheid. So that then gave way to BDS. BDS still remains a threat on many campuses. It definitely, where we see BDS on campus, we see a worsening of the climate for Jewish students generally, as well as for Israeli American students. But what we're also seeing is problems, you might say, post-BDS on some campuses. There may or may not be a BDS resolution on the table. What we're seeing increasingly now is what you might call anti-normalization, efforts to stigmatize Zionism and to exclude Jewish students and Jewish groups from progressive spaces, or more generally from campus spaces, based on the notion that Zionists are not legitimate. We're seeing this used against Jewish students as a fairly potent weapon, and I would say that that is the number one thing we need to confront right now.
Thank you. And this might tie into the answer that you just gave. Earlier, you had talked about how there are constitutionally protected forms of anti-Semitism versus forms of anti-Semitism that are not protected by the Constitution. Would you be able to give some examples of anti-Semitism that are constitutionally protected?
I don't want to encourage people, but I'll say generally speaking, administrators are on better grounds when they can address conduct as opposed to speech. So there are some areas in which people engage in pure speech. My advice to administrators, though, is that if they are on notice of significant anti-Semitic speech on their campus, even if it's a public institution where they are prevented from punishing the speaker, that doesn't mean that they have to stay silent. They can speak out themselves, and they have a host of things that they can do. The First Amendment provides parameters within which they can address hate and bias incidents, but it is never a reason for them to do nothing.
Thank you. And then another question we have, does the Department of Education have the ability to inflict fines or take any other action against universities who don't protect students from anti-Semitism or BDS?
Only a very, very big one. Technically, there is only one major sanction that OCR can do. In nearly every instance where OCR finds a violation, it enters into a voluntary resolution. If the institution does not voluntarily comply, OCR, in conjunction with either administrative law judge or alternatively the Department of Justice and a federal court, can eliminate all federal funds whatsoever. So OCR doesn't have the ability to make a minor fine, but it can facilitate the elimination of all federal funds whatsoever.
Thank you.
Can I just ask something there? Is that because of the executive order? If it's an if you find that there's anti-Semitism, I seem to recall that President Trump had said that all federal funds can be eliminated from, or was this in existence before?
It was in existence before, and it's because of the strategy that was used in 1964 when the Civil Rights Act was passed. The notion was that if an institution receives federal funds, it should not be able to use those funds to support discriminatory behavior. At the time, they were thinking mostly about racially segregated schools, but the principle has been applied more broadly. And of course, since then, the federal role in funding education has expanded quite dramatically. So the purpose of civil rights administration through agencies like OCR is to ensure that taxpayers aren't essentially funding discrimination. If OCR finds a violation and the university won't comply, then the department ultimately would have to turn off the spigot, as it were.
On that note, is there an instance of all federal funds ever having been withdrawn from a university?
If so, it certainly hasn't been in the last 20 years. I'm not aware of it. It's possible that in the early years of the agency, there have been cases that have gotten close within the last 25 years or so, close enough that there's been a hearing, for instance. But they have invariably led to a settlement at some time or other. Even in the one case within the last 25 years or so, in which there may have been an actual court finding, there's always a resolution. I'm not aware of cases in which funding has been cut out altogether. If there have been, it would have been an early case.
Thank you. Another question we have: do you feel that Israel normalizing with Arab countries such as the UAE will increase anti-Israel, BDS, antisemitism on campuses as a result?
No, but there are other factors that are leading to the increase. I think, generally speaking, the increase in political activism, especially extremist political activism, tends to bleed into Israel. Not all of the recent collegiate political activity has been as Israel focused as in some past years, but some of it has been. Often one of the indicators of increased campus anti-Semitism has been turmoil regarding Israel. So if the process were to break down, or if there were to be a significant increase in Palestinian agitation, it could translate, or perhaps if there were some change in the status of the settlements. But I don't see the peace agreement as worsening the situation.
Thank you. The next question: we've been talking about issues at universities, but what about K through 12, or particularly high schools? Are there any federal departments that pursue issues of anti-Semitism in US high schools?
Yeah, the same one, OCR, and I try to put a little more attention on K-12 for anti-Semitism, just as in other areas. As I indicated earlier, I think we try to raise public awareness that Title IX wasn't just for colleges and universities, but that there are distressing problems in many public schools as well. And similarly for anti-Semitism. In fact, if you look at the most recent ADL audit, you'll see that in elementary and secondary schools, the problem has been especially spiking in the last year. At OCR, I made the following recommendation that has been pending notice and comment, and that is that the agency begin comprehensively seeking data on every form of religious discrimination and harassment in elementary and secondary schools, including anti-Semitism and other forms of religious discrimination. Now, the Brandeis Center had advocated several years ago that the department start tracking religious discrimination, and it did. And just about 3 years ago, partly in response to the Brandeis Center's advocacy, OCR issued the first set of numbers and showed that there were, in the first year, 10,000 incidents of reported religious discrimination and harassment in the public schools. First year numbers are sometimes unreliable, but if anything, the actual numbers tend to be a little higher because first year reporting is voluntary. So we'll need to keep an eye on whether that number increases during subsequent collections of the civil rights data collection. I'm hoping and expecting that the department will start with its next collection, asking more specifically where those 10,000 incidents are directed. Is it against Jewish students, against Muslim students, Christian students, Hindu students? What we need to have is a much clearer sense of where the problem is. And I think the department is moving in that direction. And I hope and expect that for the next data collection, we'll have a much better picture.
Thank you so much. I think we have time for a few more questions. So another one, with college classes moving to an online format, it might be likely that BDS and anti-Semitism in university forums will begin to appear online. Does this mean that the jurisdiction for combating such hate crimes will fall under another authority outside of the Department of Education, since it would be more cyber crime related?
It's still OCR, although there are some forms of online hate and bias that aren't within the responsibility of the school. So there's sometimes a difficult question about whether the school is responsible or not. But there's some forms of cyber discrimination that clearly are the school's responsibility, especially if it involves school technologies and school Zoom or other classes. On the one hand, you would think that how can there be campus anti-Semitism if we don't have campuses? The closure of many campuses you would expect would reduce some forms of harassment. On the other hand, we're seeing huge numbers of Zoom bombing, racial images and epithets, either coming from outside groups, which can include the KKK and neo-Nazi groups, as well as ethnic and racial stereotypes from students. So yes, we're seeing a lot of that already. We should be ready for more of it, and OCR is the agency that is addressing it.
Thank you. Another question we have. Would you be able to address the matter of retaliation against staff and faculty who have come to the defense of students that were discriminated against as a result of anti-Semitism?
Sure, and we do see that. There was I would say, a powerful and distressing volume published about 3 years ago or so by Andrew Pessin and Doron Ben-Attar about anti-Zionism in higher education, which tells the stories of many professors who faced attacks either for their advocacy or for their support for students, and the sheer volume of those incidents is very sad. It is illegal to retaliate against students for exercising certain of their rights, including their right to petition OCR, and OCR does have protections for those retaliation, but they're not unlimited. And so, for instance, if a professor is supporting a student who is filing an OCR claim, there are legal protections. In other cases, it's a little trickier, but we certainly are available at the Louis D. Brandeis Center to talk to faculty members who have problems along those lines and can counsel them on what they need to do to stay safe and protected.
Great. And I think this will be our last question. Has your office ever worked in suggesting legislation to regulate foreign funding to universities with the IRS?
I'm not sure if by our office the question is about the Louis D. Brandeis Center or about OCR, but either way, I can't think of any instances where we've urged IRS involvement of that sort. We've looked at other IRS issues, including whether certain organizations are abusing their IRS status, but we're always open to different sorts of ideas.
Thank you so much.
Thank you so much. I have to tell you that this is a passion of mine, as you know, Ken, and I'm very sad that you're no longer with the Department of Education, but extremely happy that you're back at the Louis D. Brandeis Center. And in your civilian mode, I hope you don't mind if I continue to pick your brain to try to work on maybe a petition or a letter which will actually look at regulations and how it would make it easier for the Office of Civil Rights in the future to be able to enforce both Title VI of the Higher Education Act and Title VI of the Civil Rights Act. And I do want to leave with a favorite quote of mine, and that is from the philosopher Heinrich Heine, who said that many a revolution is caused in the still of the night and the loneliness of a professor's study. So ideas matter and words matter. And there are many times when professors are actually helping to instill ideas that sometimes can be very, very helpful, but sometimes could be extremely harmful, and that give a kind of intellectual validation to this age-old prejudice of anti-Semitism. So, you know, although it's easier to be able to enforce violations of conduct as opposed to violations of speech, we also have to be very careful about what in the name of free speech is being taught by these professors. So, well, I just want to leave you with that, and thank you so much for your amazing service to our country and also to the Jewish people.
Thank you, Sarah. It's been a pleasure.
Okay, take care. Bye-bye.